All right, and we're going to go live in 5, 4, 3, 2, now.
Good afternoon, colleagues. This is the USTPC Hot Topics event for the month of May. We have a excellent topic today and an excellent panel. We appreciate you joining us. A few administrative comments to get through. You should know that we will be recorded, so keep that in mind. If you are a journalist, this is on background, and so we are doing live captioning. Microphones are muted. There is an opportunity for you to chat with the panelists, but not with each other. And there is an opportunity for questioning. So if you have a question, click the Q&A button, and that will allow you to submit a question to the moderator. And our moderator will filter out the questions and sequence them as he deems appropriate to present to the panel for discussion. And if you have need assistance, send a message to the ACM policy, and that message will be received and responded to. The USTPC mission is essentially, we are the US component of the ACM's Technology Policy Committee. We are the focal point for interaction with the government organizations and the computing community for public policy. And so it's an exciting myriad of things that we get into in different policy issues associated with technology, largely with computers, and obviously things that are of interest to ACM members. It's all matters of US public policy on information and technology and computing, and that's really the key here. So that's, again, why you're members of ACM, and again, we're very glad that you've joined the meeting today. USTPC is authorized to take official positions, but not on the behalf of ACM, but we do take positions on these things. And like ACM and any of our other organizations, we are a non-lobbying organization. One of the key aspects of our meeting today is to disseminate information and things that we do and work that we do, and to advertise to some extent what we do in USTPC. And so we are soliciting and seeking members in USTPC. Now, that doesn't mean we have a goal of having 300 or 400 members. We're not looking for a mass enrollment. But if you have an interest in technology policy, and that's not one particular policy that is of interest to you or one particular issue, but if you're interested in technology policy, we'll hope you consider joining USTPC. And that simply requires you being a member of ACM, and your membership needs to be current. Then you can email our Adam, our public policy office, in charge at acmpo.acm@acm.org. Send your name and your ACM number and a short bio. Then we have several subcommittees that we use to be able to emphasize and look through our issues and analyze our issues. And we'd ask you pick at least one subcommittee. Most members generally will pick more than one, but you have to have at least one. And then that request for membership will be reviewed by the Secretariat, and then you'll soon receive an email welcoming you to USTPC, where you'll get access to our mailing list, and you'll be on the access to this type of event, our hot topics and other things as they're going on, and be able to participate with USTPC. So if you have interest, please reach out to us and let us know at your soonest. As I mentioned earlier, we have a great panel put together today. Andy Grosso is our chair. Adam, you want to go ahead and advance? Thank you. Andy Grosso is our moderator. He is a longtime legal technical policy representative on our committee. He's a former assistant attorney in Florida and Massachusetts. I've worked with him with several different groups in which he is recognized as an expert in this area in many aspects of technology policy, but certainly all aspects of technology policy associated with government issues. And so we're very proud and pleased to have Andy, who's put together a great panel, and I'll let him introduce them to you. Andy, you've got it.
Thank you, Alec. My name is Andy Grosso. I am an attorney in Washington, D.C. As Alec mentioned, I used to be an assistant U.S. attorney, a federal prosecutor, and I also have an interesting background in computer science that helps me understand what these issues are. We have a good panel today. We are going to approach a topic that really demonstrates the intricacies of the connections and the conflicts between technology and law. We're going to reconsider and revisit a couple of cases that have been active in the last few years. One is the case of Van Buren against the United States, which the Supreme Court decided last year. The ACM put in a brief as an amicus, and our position, if not all of our specific arguments, was accepted by the court. And that intersects yet another important piece of litigation that's currently still ongoing. It's called HiQ against LinkedIn. And out in the Ninth Circuit, that's in a case coming out of California, the district court there was faced with an interesting issue regarding the Computer Fraud and Abuse Act, which is really where we're heading. We are going to visit what happened in both Van Buren and in HiQ against LinkedIn. I will go into that a little bit more in a moment. What I want to do is introduce our panelists. We have 4 of them, all experts in related but yet very significantly different fields. And the first I want to introduce is Megan Iorio, who is currently senior counsel with the Electronic Privacy Information Center, otherwise known as EPIC, in Washington, D.C. She is also the director of amicus curiae briefs for them. Formerly, she was the organizing director of Just Foreign Policy, an organization that's involved in promoting progressive foreign policy issues. So she has a solid background in policy before she went to law school, and she's now using that background in promoting the policy interests espoused by the EPIC organization. Our second panelist is Lorraine Kisselburgh, who I have known for about 20 years through the ACM. She's a former professor at Purdue University. She's a social scientist who studies the implications of emerging technologies, including privacy ethics and the technological impacts of social interactions. She served as chair of the ACM's Global Council for Technology Policy. That's a council that's a step above this organization that is putting on this particular panel today, the United States Technology Policy Committee of the ACM. She sits on the Global Council that looks over that organization and our sister organization in Europe. She was a member of the 2018 task force to revise the ACM's Code of Ethics, and she currently serves on the policy board of directors for the Center for AI and Digital Policy, as well as co-chair of the IEEE AI Governance Standards Committee, that is for artificial intelligence. Jody Westby is on our panel today. She is CEO of Global Cyber Risk, a cybersecurity advisory and technical services consulting firm. She is an adjunct professor with the Georgia Institute of Technology School of Computer Science and was previously an adjunct distinguished fellow with Carnegie Mellon Scilab. She has been a senior managing director for PricewaterhouseCoopers for information security, privacy, information sharing, and for critical infrastructure protection issues across the federal government. Our final panelist is a longtime friend of mine for about 25 years, Mark Rasch. Mark is a computer security and privacy expert, as well as a lawyer, and he's an adjunct professor of cyberlaw and cybercrime with the George Washington University School of Law. He served as a trial attorney with the U.S. Department of Justice, where he was involved in the drafting of the original version of the Computer Fraud and Abuse Act, and he tried the first criminal prosecution under the Act, United States against Robert Tappan Morris. He is a frequent commentator in the media on issues related to information security, and is the author of hundreds of articles about the internet privacy, hacking, cryptocurrency, blockchain, and ransomware. With that being said, I want to lay out a little bit of the background regarding the CFAA, or the Computer Fraud and Abuse Act. Mark will tell you a lot more about it than I will, but it was drafted in the mid 1980s. And it, among other things, and this is one of the laws that I consider to be a Chinese menu statute, pick an element from column A, an element from column B, and from column C, you get the penalties involved. But among other things, it prohibits accessing without authorization or exceeding authorized access a protected computer, and thereby obtaining information from that computer. Today, protected computer means almost any computer, because it means a computer that's connected to the internet, that specifically a computer that's used in or is affecting interstate or foreign communications or commerce. The problem that we have is in the term authorized and exceeds authorized access. The statute has a definition for exceeds authorized access. The problem is it's unclear. When technology meets the law, this happens quite often. In Van Buren, there was a question as to whether a police officer's decision to use the access that he had, he was authorized, to obtain information about a person, but doing so in order to help someone who was paying him money to look up private information.
And there was no, okay, we're back to recording, good. There is no good law about the idea of theft of information, whether you steal information. So the Computer Fraud and Abuse Act had a couple of things it was trying to do. One is it was trying to get at this concept of theft of information. And the second, it was trying to apply the general law of trespass, breaking and entering, or general common law trespass to computers. And to a good extent, it succeeded on both for the detriment of the law. And a lot of the problems that we're having today about the idea of theft of information or computer trespass actually are problems related to the theft laws and are problems related to the trespass laws. And so the statute was designed to try to incorporate these types of problems, and they incorporated those concepts and all the problems with them. And as Andy pointed out, what the statute does, both from a criminal and a civil standpoint, is it makes it a crime as well as a civil action for somebody who either accesses a computer without authorization or exceeds their authorization to access a computer. Now, the problem is, one, what is access? What is authorization to access? And what is exceeding authorization to access? And in the case that Andy was talking about that I prosecuted, this guy, Robert Morris, essentially sent a worm out that harmed a bunch of computers. Didn't intend to cause harm, but it did cause harm. So the first problem is the worm accessed the computer, the defendant didn't. Was that access? The second problem is it used a vulnerability in send mail. Well, you are authorized to send mail from one person to another. So was his access unauthorized? And the third problem is, what do we mean by exceeding the scope of authorization? And there are really two ways to exceed the scope of your authorization. One is common hacking. I do something to defeat a technological method or barrier keeping me from going somewhere. I break in. Now, I don't know all the different ways I can break in, but I break in. That's one conceptually. The second one is I go somewhere or do something that the owner of the computer, the owner of the system doesn't want me to do. I violate the rules. And so for years, because this was civil and criminal, we had litigation over which one of these was exceeding the scope of authorization. And because it was civil, you'd have cases where, for example, a company hired a bunch of people, gave them access to the computer data, said, but don't give this to anybody else. And then they would leave the company and they would steal data with them. they would take the files to start a competing company, and that there would be a lawsuit. And that question is, did they exceed the scope of their authorization? And the answer was courts were all over the map on that one. So that's where we were when we get to the Van Buren case. We have some courts saying, no, hacking is just hacking. Some courts saying, no, if you just do what you're not allowed to do on a computer, that's also a violation of CFAA. Van Buren was a case in which a police officer had authorized access to a database of crime information. His access was limited to police use. He agreed he would only use that access for legitimate law enforcement purposes. He then used the data that he had lawful access to for non-police purposes. He was accessing the database for non-police purposes. And the question for the court and for the 11th Circuit originally was, did he exceed the scope of his authorization to access that computer? And the Supreme Court said, we're going to read the statute narrowly in accord with what Andy talked about, the rule of lenity, where you read criminal statutes narrowly. And we're going to say that to access without authorization, to exceed authorization, means to hack. So to access without authorization means you have no authorization and you go in. To exceed authorized access is you have authorization to go here and you hack into there. And that's what the Supreme Court said essentially in Van Buren. Now, HiQ. This is all a high-level discussion of what it is. In HiQ versus LinkedIn, LinkedIn is a huge database that collects a bunch of information about people. And it is public. And I use that term in quotes because people share information with LinkedIn for particular purposes. And people shared it with LinkedIn. And then HiQ had a great idea. They said, you know what? We're going to suck up all that data through automated scraping. We're going to use the data that people have put onto LinkedIn, and we're going to create a database and an AI program that's going to help those people. I think it was for job training. I think it was. I don't remember what HiQ's program did. LinkedIn said basically, look, we've invested millions of dollars to attract people to LinkedIn. It's our database, even though it's public. And they had a policy that says no scraping, no automated scraping of the information. And that was their policy. HiQ started scraping. LinkedIn cut them off, put up technical barriers to cut them off. HiQ bypassed the technical barriers. LinkedIn cut them off again. HiQ bypassed those. LinkedIn cut them off again. Finally, LinkedIn sent a letter, said, stop doing it. You're not allowed to do it. You're not authorized to use our system this way and for these purposes. We're going to sue you if you don't stop. And instead, HiQ sued LinkedIn to get permission to scrape the data. And that's really the issue, is to what extent can a website operator like LinkedIn restrict access using the criminal or civil laws of other people? To what extent do they get to set up rules of the road by policy saying what people can access and why? So there it is. That's setting it up. And there are all kinds of privacy implications. There's criminal law implications. There's civil law implications. There are questions about whether you can restrict your database, no police access, international access. How do you enforce rules from a technical standpoint? And how do you do it from a legal standpoint?
You're done?
I am done. I'm setting up. I'm not taking a position yet. We'll do that during the yelling part.
All right. All right. I want to turn to Lorraine. Are you there?
I am here. Can you
All
see
right.
me? Can you hear me?
I can hear you very well. Lorraine, you have some
Okay, thank
professional
you.
concerns that you can raise about this particular dispute.
Yes, so thank you and good evening, everyone. And also as a quick preemptive remark, I am not the lawyer in the room. Everybody else is a lawyer, so I'm speaking primarily on technical issues and societal implication. But I, even though I'm speaking about the cases, rest assured, I never claimed to be an expert in the law. But there's three issues I'd like to draw attention to in this discussion. First is to mention why ACM and USTPC has an interest in these cases, and specifically protecting computational research and analysis. Second, I want to talk a little bit about the technology behind the case. Mark started to introduce some of that. I'm going to elaborate that just a bit. And then finally, I want to end talking about the ethical responsibilities that we have as data collectors and analysts, and specifically responsible stewardship. And hopefully that will give a good segue to Megan, who will be speaking more about specific privacy interests in this case. So first, let me step back slightly from the cases and talk about what is ACM's interest in the case. And essentially what we are interested in is this is on behalf of computer and data professionals. So the Van Buren case that Mark introduced raised these concerns that there was an overbroad interpretation of CFAA, and that could potentially criminalize practices of computer scientists, data scientists, computational social scientists, anyone using large-scale data for research, analysis, and reporting. And so that was a chilling effect, potentially criminalizing access to online data sets that could also potentially inhibit research and innovation. And so in the amicus brief that USTPC filed in 2020 for the Van Buren case, we provided examples of research practices that could be criminalized, such as researching new data extraction techniques, researching dark patterns on shopping websites, auditing race and gender discrimination in online housing markets, investigating sources of personal information used in targeted advertising, or most recently, building a dashboard to track COVID-19 cases in real time. So because the decision of HiQ versus LinkedIn adopts a more narrow position, stating that the data stored on publicly accessible sites is not specifically protected from access by the CFAA, we think this threat might be removed. So second, what I want to talk about a little bit more is the technology behind the case. First, it's important to acknowledge the obvious. The technology has evolved light years since the CFAA was enacted in 1986. So for those of you who are old enough to have been around during that time, you will recall 1986 was pre-internet, in the early stages of what we called local networks, wide area networks, and so forth. So access generally required physical access to a computer, and it typically a password-protected account in order to see data. So of course now, unauthorized access or hacking is primarily a digital practice. We have globally networked infrastructures with a ubiquitous web layer, which means most access requires only a digital address, and intrusion is not physical but digital. But let me clarify a couple of the terms and technologies that are used in this case. First, data scraping, which is also called web scraping. You can argue it, they tend to be used synonymously. But essentially, scraping is a process of using a tool to extract content and data from websites and copying it into a structured file for further analysis. So this can be both public websites and it could be websites that are only available to individuals with account authorized access. It can also be done manually and was done manually for a long time, but is typically done by an automated script or a bot. So at the scraper end, the bot is simply an app that automatically crawls the web, retrieves, stores, and analyzes data that it finds. This part is a web crawler, and a web crawler is a common type of bot that searches the internet, downloads content from web pages in order to index search engines that we all rely upon, like Google. But at the host site, there's another component, and that's called the robots.txt file. And essentially, it's a coded set of rules that communicates with this automated bot app, this scraper app, this web crawler, to indicate here are the rules for what you can see on this site where you are. And it may indicate pages that they consider public and accessible, pages that they do not. But adherence, compliance with those rules is voluntary. So malicious bots may deliberately choose not to honor the rules, and when they're found, they can be punished with a denial of access. Some bots are given, like Google, are given very explicit permission broad permission for access. Others, I think they monitor the ways in which they're using and determine whether or not they allow them to continue. But there are important differences then between legitimate and malicious bots. First, legitimate bots are clearly identified with an organization that's doing the scraping. But malicious bots tend to impersonate legitimate traffic and creating false user agents. Also, legitimate bots are assumed to comply with the site's robot.txt rules. And malicious scrapers, on the other hand, will crawl regardless and are basically not complying with those particular coded rules. So in this case, as Mark has already indicated, the site is LinkedIn, professional social networking site, 500 million users, and it allows members to choose privacy settings for their profiles, specify which portions of the profile are visible to the public and which are visible only to their member networks. It also, obviously, and I think Mark mentioned this, employs detection and restriction of automated scraping, whether it's non-human scraping or whether it's suspicious IPs, and blocking IP address from large-scale scrapers that are not. And according to their report, they block approximately 95 million automated attempts to scrape data every day. So we're talking about massive attempts in there and a very challenging environment. So the scraper in this case is HiQ, and it's a data analytics firm which specifically was generated to scrape from LinkedIn public profiles, name, title, and skills, and then generate analytics that it sells to business clients. Two of those examples were identifying employees at risk for being recruited away by another company. Another one was simply summarizing at an aggregate level the kinds of skill gaps in their workforce. So valuable information, but what happened, and this is a lesser known part of the case, is that LinkedIn decided they would like to be offering those services as well. So you get a competitor situation here, and that's when they turned off HiQ's access. So another question when we talk about terminology is what is publicly accessible? So the decision of the HiQ case is clear that scraping publicly accessible data is not unlawful. And they indicate that publicly accessible is intended to mean no physical or technical barriers to access, such as a password, robot text instructions, and so forth. Authorized access is a little bit more essentially no mechanisms and or that permissions have not been explicitly granted. So finally, again, I'm jumping to a third point, which is if it's not unlawful, then what are our ethical responsibilities as data collectors and scraping? Because there's no federal law, even though there are state laws in place, that prohibit this practice, we need to rely upon what we call professional standards and guidelines and codes and so forth to ensure that we have responsible stewardship and protection of the data. So our understanding of data privacy has been complicated tremendously over the years by social media technology, as well as this huge growth in industries built on the commodification of data. I'm going to give quickly, there are two cases that illustrate the complexities of these issues, certainly not the only, and Megan will talk about more, I know. Cambridge Analytica is one that's known by many, and the collection of data was authorized under an API agreement between Cambridge researchers and Facebook, and then users disclosed data as part of an online research study. That data set was then shared with a third party, Cambridge Analytica, which aggregated that data about human behavior and motivations with demographic, geographic data, and they created data sets that was subsequently sold to fourth parties, political campaigns to manipulate information in elections. Clearview AI is another one, essentially, which scraped a massive number of images from social media profiles, then used this data set to train a facial recognition model, which they've subsequently sold to law enforcement agencies, increasing vulnerabilities for those whose data was shared. So lastly and quickly, I'm going to call your attention to what do we do in the absence of laws in here. And so one thing I will share is the ACM Code of Ethics, which includes actually two specific sections on authorized access and data privacy. And the authorized access 2.8 essentially is access computing resources only when authorized to do so when compelled by the public good. And so this section in here essentially indicates that computing professionals should not access another computer system without a reasonable belief that the action is authorized or that is consistent with the public good. And a system being publicly accessible is not sufficient grounds on its own to imply authorization. The second clause of interest is the one on privacy. And here it indicates specifically and talks about some of the issues regarding privacy in data scraping. In the indication, they take precaution to prevent re-identification of anonymized data when they have been aggregated, unauthorized data collection, understanding the provenance, the ownership of the data as it goes from second to third to fourth parties and so forth, and to protect it from an unauthorized access. And again, talks about specific purposes, again, a number of deep privacy principles that need to be followed and kept in mind by designers, as well as data analysts and scientists who are using this. So when we have time to discuss, I also want to be able to bring up some questions about distinguishing the rights to personal data. But right now, what I want to end with is saying that this decision affirms that digitally scraping data from publicly accessible websites is not unlawful, and it removes important threats to criminalizing the practice of computer and data scientists. But we're also bound by a code of ethics to be responsible stewards. So with that, I'm going to end my comments.
Thank you, Lorraine. We're moving on to Megan. Are you there? There you are. Megan and I have a disagreement as to the correctness of the Ninth Circuit's decision. I'm not going to tell you what my position is right now, but I'm going to ask Megan to tell you what hers is. And she not only, she's filed a brief in this case, so she knows the case probably better than anyone else on this panel. But there are aspects of concerning the argument in the Ninth Circuit that go beyond just the CFAA. So I'm going to ask Megan to tell us what's going on in that case and why the Ninth Circuit is, I think you said, wrong, right?
Yes, you got it. Hi, everybody. Yep, so I run the amicus program at EPIC, the Electronic Privacy Information Center. We filed two briefs in the HiQ case, one in the Ninth Circuit several years ago, when the Ninth Circuit was originally considering this case before Van Buren. And then I also filed a brief in the Supreme Court when LinkedIn was looking to get cert to have the case heard up there. I also filed a brief in the Van Buren case on the CFAA, but right now I want to focus on the HiQ case and our particular concerns with this case, which are not really with the CFAA, but more with the court's failure to recognize and properly weigh the privacy interests in data made generally available to the public, both in balancing of the interests and in considering the LinkedIn's defenses, and I'll get to that specifics in a moment, as well as the general issue of granting an injunction that requires a website operator to give a data scraper access to personal information. So first, take on the privacy interest. So district court and the Ninth Circuit essentially said that if you make information available to the general public at a specific time and place and for a particular purpose on the internet, then you have no privacy interest in that data. And we think that they failed to recognize the distinction between the privacy impacts of viewing publicly available data, and then of collecting that data, and then using that data for harmful purposes. So when people make information about themselves publicly available, they do so at in a particular time, a particular place, and usually for a particular purpose. And the person can make the information public, and then they can later decide to restrict access, change it, or delete the data entirely. But when someone scrapes data, that creates a separate record that the person who supplied the data doesn't have control over. They also don't have control over the uses of that data anymore. So, and there's another issue of that the original data collector has obligations to the user, as set out in various user and privacy policies. The original collector would have to change its privacy policy and add new uses and inform the user, or else they face litigation. The scraper, in most states and in most places in the United States, because we lack a comprehensive federal privacy legislation, has no obligation to most people. The best way to illustrate the privacy interest in publicly available data is an example that Lorraine just brought up, and that's Clearview AI. So people on the internet regularly make their profile pictures publicly accessible so people can find them and verify that the account belongs to the person that they know. Think Venmo profile pics. That's to verify I'm sending that money to the right person. But Clearview scraped Venmo profile pictures and lots of other profile pictures, and then created something very harmful with it, a facial recognition system. And our view is that people have to choose between making certain information about themselves publicly available and winding up in a facial recognition system or some other kind of harmful surveillance or decision-making system, like, am I credit worthy? Or can I get this job? So again, the courts in this case fail to appreciate the privacy interest in the public LinkedIn data. And that's in large part why this injunction was granted, both in the balance of the equities and the defense to the interference with contract, tortious interference with contract claim. I think that those would have come out differently if the court had actually appreciated the privacy interests. But more generally, it's concerning that a court can force a website to allow scrapers to scrape their user data. The facts in this case might be limited to, the injunction in this case might be limited to the facts in this case in particular. As others have pointed out, the court focused on the similar products that LinkedIn was planning to offer and spun it as LinkedIn trying to eliminate a competitor instead of LinkedIn protecting the privacy of its users. And that wouldn't work if, say, Clearview tried to get an injunction to force LinkedIn to give them access to the website, which makes me feel a little better about this case. But I think that as a general rule, any kind of right to scrape personal data, as personal data, not just any data, should be given a hard look. And if it allows systems like Clearview AI to operate and to force other data collectors to allow Clearview AI to have access to their data, that's a huge problem.
Are you done?
Yeah, I'm done.
I'm going to come back to you. I've got some questions for you, but before we do, we're going to move on to the international arena and issues concerning security and conflict of laws. And we're going to go with Jody. Jody, welcome.
Thanks everybody for joining. Thanks, Andrew, for inviting me. So I don't think the Ninth Circuit was wrong. I think LinkedIn screwed up. LinkedIn first screwed up because and Mark, I'm going to narrow what you said on this a little bit about why it brought this suit. It says HiQ filed an action seeking injunctive release based on California law and a declaratory judgment that LinkedIn could not lawfully invoke the Computer Fraud and Abuse Act, the Digital Millennium Copyright Act, California Penal Code 502C, or the common law of trespass to chattels. So they put it in the CFAA box, the Computer Fraud and Abuse Act. And you just kind of forget all those other things. They kind of go away. But the first mistake LinkedIn made was they didn't own the data. Now, why wouldn't they own the data? I go to a store, I go online and I buy something and I put in my name and address and all that. That's Amazon's. I don't own that data in Amazon's. They own it because I gave it to them. So LinkedIn, probably because some privacy lawyer said, oh no, you don't want to own this data because then you have all these privacy problems. We'll just let the people own it. I don't know how that happened, but anyway, they said in their policy and for years, they don't own the data. We all own our own data that we put on their site. So that was the first mistake they made. And then they do make it available with no access control. And they kind of have to do that because of their business model. But the other big mistake they made was, like I said, relying on CFAA and trying to use that as a means of bludgeoning these people to stop using their data. So the first thing to remember is, boy, Lorraine, you did a great job. I'm really glad you're not an attorney and you explained this, but I don't know it like you know it, but I know that you can go out there and scrape my browsing history if you want. I know that you can you can scrape and find out what systems I'm operating on, what my operating system is. And so there's a lot of scraping that goes on out there, and it just has been commonplace since the internet was developed. And we have to remember that governments do this all the time. This isn't just bad tech companies. So the US government has saved every tweet from 2006 to December 31st of 2017, 11 years. The Library of Congress still collects pages from websites. So we hoover up data. We know intelligence bureaus collect all these tweets. They collect anything they can for public information. So again, it's not just a bad tech company who's going out and trying to grab the data. Scraping is something that's been commonplace. And it's something that maybe it's okay if it's manual, but it's not okay if it's automated. There's a little of that in there. But global websites with data like LinkedIn need to think of global solutions to this problem. And instead, they thought of a very US-centric solution and said, well, we're going to drag out the Computer Fraud and Abuse Act, and we're going to say you're subject to criminal penalties if you don't stop this. And we have to think about it. There's 500 million people that are signed up to LinkedIn. That's, the US has 330 million people. So it's the US plus another half of somewhere else. And so what's illegal in the US may not be illegal elsewhere. So they could go through this whole thing with Computer Fraud and Abuse Act, and the company could just simply go to some other jurisdiction and do it. And so using Computer Fraud and Abuse Act was just such a US-centric approach. And then we have to remember that cybercrime laws are very inconsistent globally. This is a problem I've worked on for 20 plus years. And they're inconsistent in our state laws. Our state laws have a mess of cybercrime laws. I just served on a ULC cybercrime working group and heard from all these state people that the state laws aren't consistent at all in the US. So cybercrime laws are a little bit of dragging out a junkyard dog, saying that you're going to use this as your means to block the scraping and use of the data. I think they overreached. They just dug in there and said, well, we're going to use digital millennium copyright, CFAA, trespass to chattels, and everything else we can think of. So there's also another thing, which I mentioned, intelligence agencies gathering of data. So in the US, it's illegal to collect data on our citizens by intelligence agencies. They can't do that. They can collect it on foreigners, but not US citizens. So the Five Eyes, US, Canada, Australia, New Zealand, US, and
UK.
UK, thanks. So, they can say, well, I'll collect your citizens' data and you collect mine, and then we'll exchange. And that happens. That just happens. So I think LinkedIn made a real blunder in going with not looking at this as a global solution, because if they had done that, maybe they would have gone the privacy route. Why wouldn't they say this is a privacy breach? This is a breach of PII. They're accessing all this information. Well, they didn't have to say it was a breach of PI because they could say, well, it wasn't our data. Well, wait a minute, it sits on your servers. And privacy's never had stronger legs than it does right now. And the EU has never been such a bull, as they are right now, just with everything they're doing. And with cybersecurity, the Digital Millennium, the Digital Marketing Act, Data Governance Act, Digital Services Act, they are a raging bull right now. So they could have gotten EU attention on this as well, but they instead went the Computer Fraud and Abuse Act. So I'll stop with that because I know we have lots of issues teed up, but I think the Ninth Circuit got it right. LinkedIn got it wrong.
All right. To the audience, feel free to submit questions. I am going to read the questions and I will read them to the panelists, and we will have a free-for-all for whatever issues that you present here. That being said, Megan, I told you I was going to do this. I have a gripe with you, and I know Mark is going to be on my side. You better be. As I said during the introduction, this is a criminal statute. And what I don't understand is how an organization that is focused on civil liberties in the electronic arena can take a position that that will effectively expand the use of this statute when it has both criminal as well as civil implications for anyone who is found in violation of it. Now, if you're arguing that the court cannot issue an injunction prohibiting LinkedIn from using the statute, then don't you have this matter kind of reversed from where normal civil liberties would think you would be coming from?
Couple responses to that. So one, I don't think that we mentioned the CFAA once in any of our high-Q briefs. We were focused on the privacy interests in the balance of the equities, and also in the other defenses that involved looking at what the privacy interest was for LinkedIn users. And we thought that the courts weren't properly weighing those things. But
Megan, what's wrong with the argument is I put it on LinkedIn. I made it public. It's public. Public is public.
Yeah, so that's a problem, because if you think that making something public, making some information public at a particular time on a particular place means then Clearview AI can scrape it and use it to make a facial recognition system, I think we have a fundamental disagreement that doesn't have much to do with CFAA and makes it very difficult for us to get some good privacy legislation in this country.
Well, actually, I think it goes the other way around. If we move it away from CFAA, then we can focus on what you're talking about, which is the privacy problem, not the unauthorized access problem.
Right. Well, so going back to CFAA, we did file a brief in Van Buren. We did think that there were ways to narrowly construe the CFAA's text. The courts are not interested in that. And at this point, like, I don't think the way that the Supreme Court, especially combined with the way the Ninth Circuit has interpreted the CFAA and what they want to do with it, that's not a good way to block, to do anything about the problem that we're talking about, which is scraping of personal information. Okay, if we can concede that, fine. But I'm hearing things that are more fundamental that would interfere with regulating scraping of personal data, or am I wrong there?
I'm gonna chime in. I think the problem is that the CFA is the wrong statute to make this distinction.
It's the wrong statute conceptually.
Yes, you need a civil privacy statute that says, okay, the information is in the public domain. You put it there. Now, what is your privacy interest vis-a-vis someone who wants to collect that data and commercialize it? If you don't want that to happen, you don't want to put it there in the first place. The
See,
counter
that's where we differ. I don't think that you should have to choose between making information publicly available and somebody using it to make some kind of surveillance system.
So
Well,
I'm going to
Lorraine, go ahead.
all right.
agree with Megan on this. Just really quickly, the analogy I use is intellectual property and copyright law. And if I am the author of a book, I retain the right, the ownership of that information until I deliberately give it away in some parcel or in particular form. But when my book is sold, the person who buys my book does not have rights to my property, does not have rights to copy it and sell it, resell it. When I put it in the public library, it is publicly accessible, but they still don't have rights to use my work without my permission. So I see that as a parallel path on what we're talking about here in getting away from that sense that if you put it on Facebook, then you've given up your privacy rights. And I don't believe that. So I'm with Megan on that particular issue.
So the data subjects retain a privacy right in publicly available and accessible data, and particularly where the use of that data transforms its character, the impact on the privacy. So you give it your publicly available your data to somebody, and they say, we will not use your data to sell you anything. Great. You put it out there, and all of a sudden people are selling you stuff. You say, well, we didn't do it. These other people who scraped the data did. So
Well,
that the idea that the privacy rights are retained by the data subject, and that you need some express permission to use it in a different way.
Well, but you're missing Lorraine's point, which is a good one. If LinkedIn had said they own that data, they could have said, this compilation of data we own, and this is our copyright. And it may change from moment to moment, but this is our compilation, we own it. But they didn't own the data. Now, to your point, maybe there should be, and the EU's more on this already positioned for this than we are. If you give your information to someone, no one else can use it for another purpose without your knowledge or consent.
I think Lorraine's point is that the ownership of the data resides with the data subject, and they are allowing the person they posted to.
That was LinkedIn's mistake. I'm saying they should have said they owned their database. But to the point about the ownership, I can walk down the street, the image, I can walk down the street and cameras take my picture. And if the rule is it can only be used for that purpose, collected, and can't go anywhere else, not that organization can't use it or anybody else, then that would be a law blocking the scraping. It would say, you can't do it. You have to go back to the person and ask if you can do it. Well, of course, no one's going to agree to that, Clearview AI or whatever. But we don't have that. And so everybody's taking the data, and it's a free-for-all right now.
So as your camera thing, one of the problems we have, and this is a more fundamental discussion of privacy, I'm going to bring it back to the trespass issue in a second, is that one of the big issues is there a privacy right in public information? So for example, when you're walking down the street, it's public, people can see you. And yet it's creepy for somebody to install these cameras to track everywhere you've been. Same thing about your license plates. Your license plate and where your car is when it's outside, that was the Jones case, but it wasn't decided on privacy rights. It was decided on property rights. And so the idea is that data, even data I choose to make public, has some kind of a privacy right in it. But getting back to the trespass, here's the problem with the trespass. And I love this case because I was living in Reston or working in Reston at the time. And this was a case in 1997 where this guy was in a Best Buy in Reston, a physical store. And he brought a laptop with him and a camera. This is dial-up. And he dials up and he's taking down prices of different products in the store and posting them in real time onto the web so people could comparison shop. Okay. The people at Best Buy said, "We want you to stop." He said, "Too bad, I want to continue." And they said, "No, we want you to stop." And he says, "Nope, I'm going to do it." They said, "Okay, we want you to leave." And he refused to leave. They said, "Leave the store or we're calling the police." He refused to leave. They called the police and he was arrested for trespass because he had exceeded his authorization to access the store. And when they asked him to leave, he refused to do it. That's HiQ in LinkedIn. It was publicly available information, but he exceeded his authorization, not because he didn't generally have authorization to do it, but because they told him not to do it and they kicked him out. And that's the problem with the trespass law, is that the Computer Fraud and Abuse Act takes that essential model and makes that applied to the internet.
Well, the court in HiQ cited a case, and it was Intel Corp versus Hamady, and said holding that trespass to chattels is not actionable if it does not involve actual or threatened injury to property, and the defendant's actions did not damage or interfere with the operation of the computer systems at issue. So this wasn't LinkedIn's property because they didn't own it, and it didn't interfere with or damage their operations. I mean, the other issue that's not been brought up here is competition. I mean, let's be honest here. LinkedIn was just perfectly fine with them doing this until they decided they wanted to make a competing product and shut out the little competitor that had been using their data.
And that's very common. A lot of the civil CFAA cases are cases involving unfair competition or people who are threatening to quit and take files with them and stuff like that. And they're really not trespass laws as in breaking in or breaking and entering, but they are, you're doing something with our computer system that we don't want you to do.
Well, that's Economic Espionage Act. So we can do the guy from the driving cars so that went
if they're trade secrets.
Huh?
Yeah. If those are trade secrets, oftentimes they are
intellectual property or confidential proprietary data.
Right.
Jody, Mark and I had a case, and he's smiling because he knows what I'm going to say, in the Eastern District of Pennsylvania Federal Court. And it's very similar, although there are some significant distinctions. But there, QVC had its database scraped by a smaller company, Resultly, who was our client. And QVC had in its robot.txt file, as was explained earlier by Lorraine, an instruction to scrapers, sure, you can come on in, robots can come on in, we're happy to have you there. But then they sent a cease and desist letter to Resultly saying, no, you can't come in with your robot and scrape our database. And the rationale was, we want the big guys like Google and Yahoo to come in and publicize our merchandise. We don't want the little guys making a profit off of it. And the dispute was, does a cease and desist letter override the instructions in the robot.txt file? Now, unfortunately, that case settled before we got a judgment out of it. But there, the distinction is that this was all commercial information. And of course, QVC, in my opinion, as we alleged in the court files, was being a little bit two-faced about this, in that they want the big guys to come in, they don't want the little guys to come in. But what I think is the distinction there is privacy versus commercial aspects. But also what is important, and this brings us to what Megan mentioned, the activity of Clearview. Their Clearview is not only accessing LinkedIn or Google or some other entity's database, they are accessing all of them, and they are putting them all together. Now that is much more, in my opinion, a destruction of privacy than it is what IQ is doing, going to one database, that is LinkedIn. I make my information available on LinkedIn. I cannot expect it's going to be maintained privately, even if somebody goes and takes the entire database down. It's just reproducing the database that LinkedIn has put together based upon voluntary contributions. But with the danger to privacy interests among people is that when you start cross-referencing all the databases that are available out there, you get a picture of an individual under a microscope that nobody ever expected, and in my opinion, nobody should experience. So I think the problem with the HiQ case, as demonstrated by the Supreme Court's remand to it, is that the CFAA is a statute that is designed to criminalize something that was frankly not expected to occur back when it was first drafted in 1980s, but has since been used, hence my word designed, to forbid this trespass, as Mark calls it. But it criminalizes something that people have voluntarily subjected themselves to. I don't think it's fair to say that they voluntarily subjected themselves to somebody using computers to download massive amounts of data from multiple websites to get a picture of you that you never expected to be out on the web. Anybody have any comments?
So let me ask you this, Andy. Can somebody kick you? Can you kick somebody out of the library for making too many copies of the book?
Yeah, you can, because it's copyrighted. I don't think the database in LinkedIn is copyrighted.
All right, so that's the Aaron Swartz case, of course. MIT attempting to kick Aaron Swartz out of the library, out of the database, because he was downloading and making available copyrighted works.
Stop. You've just gone over the line. There's no evidence that he was making it available.
Well, okay, he was not making it available, but he was copying it.
And the copyright did not belong to MIT.
That's true too.
But the point is, it belonged to anybody. It was adjacent.
This is the problem with the trespass law. Is there's one way to interpret the trespass law is two things. Number one, if I'm going somewhere I'm not supposed to go, but if I'm doing something that the owner of the computer doesn't want me to do, can they kick me out? And that goes to the question of cease and desist letters, the cat and mouse, I kick you out, you go around it, that kind of stuff. All right. And one of the interesting things, by the way, the California Penal Code, section 502C2, says that it is illegal for anyone who knowingly accesses and without permission takes, copies, or makes use of any data from a computer. You think the CFAA is broad? That's incredibly broad.
Okay, I promised people that I would let them ask questions, and I'm going to keep my promise. We have 3 questions. One is from Mr. Pisa, and the question is, what if someone scrapes information from another country? Do the restrictions or policies that we are discussing affect that person? Jody, you want to take a crack?
Well, first of all, if it's in another country, that country's laws are going to apply. You can try to say US law will apply because you reached into the US to commit the act. But it immediately brings up a conflict of laws situation. And then it brings the same thing. The first issue here is always a contracts issue. What are the terms of use say? And what can you do by contract or policy? And so if you have restrictions on the policies and it's a user that is bound by that terms of use, then yes, those could kick in. But that's a very different remedy than if someone is violating a legal law, a law or a regulation.
Anyone else?
All I would add is that lots of countries try to apply their laws extraterritorially, and so it makes it an unholy mess.
Yeah.
Okay, we have a lengthy question here from Michael Brady. Quote, so let me see, CFAA grew out of corporate ownership of data. That's pretty much all there was in the 1980s. Mark, you agree with that?
Yeah, no. So the CFAA, when it was first passed, was again a trespass law preventing access, restricting access to computers and computer networks, and a data theft law. But as it was originally written, it limited the data theft to specific, discrete kinds of data that were already protected by federal law. So classified information, federal banking information, including credit reporting agency and stuff like that. And I forgot one other kind of government information. So it made it illegal to access a computer and steal those kinds of information, and that's it. In one of the various amendments to the CFAA, they expanded it from accessing without authorization to exceeding authorized access. And that was as a result of a case called Kubinsky out of the First Circuit, involving an IRS agent who was looking up IRS filings and giving them to his friends who were part of the Ku Klux Klan. And then the First Circuit said, well, that's no crime. Okay, no crime, it's data, you know. And so they went into the concept of exceeding authorized access. And the second thing they did is they eliminated these narrow categories of information and said, and obtains any information. And that was a huge broadening of the statute. But go ahead.
All right, I'm going to skip down to the last part of the
and by the way, very few corporations were online at that time.
In fact, I would guess almost none.
Banks and a couple of think tanks.
Yeah.
Like SRI was online and the government contractors.
Okay, back to the question. Quote, so we need something different, but doesn't LinkedIn have a responsibility to protect the privacy of those using their system? Sounds like under US law, they don't. But then again, it's your data and you license it to LinkedIn. Do you license it? And LinkedIn doesn't say that the license is actually to everybody in the world.
Well, it's a contract. I mean, you sign up for LinkedIn, you agree to their terms of use. So that's the first thing. And then they say, we don't own the data. So you give them your data and you post it out there and they give you certain benefits in return. People can look for you and do that. And that's, that's your consideration. You give it to them, but they don't have an obligation. They say they don't own it.
One thing we can do, and I like the idea of licensing, I'd like to hear Megan's on this, but we can have a dual licensing scheme. You don't typically license your data to LinkedIn, you just post it. But maybe if we had a thing where I license my data my personal data to LinkedIn for specific purposes consistent with what LinkedIn does. And anyone who then scrapes has to agree to that license. And if they violate that, then that's actionable.
Well, then what about APIs? Why don't instead we have alternate routes of accessing data in a controlled way that creates a duty on behalf of the original collector to ensure that the data is collected and used according to certain contracts?
Well, let's say LinkedIn uses it in accordance with what the user of LinkedIn said you can do. Okay, LinkedIn is doing everything its user wants. The problem is when somebody scrapes it, they're not a party to that contract. If you can't enforce that contract through a trespass law, then how do you force the third party scraper to respect the privacy rights of the data subject?
Well, that's why I'm
So-
saying that's why you block scraping and then you force them to go to the API to obtain the data.
Of course, the API is the Cambridge thing where, you know, the developers had the API to access this data, but Facebook in its horrible
I would-
governance model doesn't do anything to even try to see if anybody's complying with these terms. So there you had, you know, a breach of contract that was really very gross. And I mean, I don't remember enough of the details about that, whether Facebook had any obligation to these users. I don't know that they did, but they did have the contract with the developers.
The problem with APIs, I had material I was going to talk about with this, but no time to cover it. The terms by what and the stipulations and rules for accessing data through an API are oftentimes quite different than they are for scraping or rules.txt, these kinds of things that are different. And API is kind of a backdoor that is given to authorized or accepted people who want to have access. And the companies like Facebook and others typically will count that under the terms of service as third-party partners, and that we won't share it with anybody or sell it with anybody except our third-party partners. And for the purpose of marketing or purpose of research, they give academic researchers access to that. But the rules and the knowledge of what is being shared and who has ownership of that and the rights of refusal, if you will say, are quite different than others. So the API is really a different body, and it's used somewhat unfairly by companies to provide selective access and broad access to very private data.
Right.
And pointing that out, you know, most of these exceeds authorized access cases come from breach of contracts, either terms of service, software license agreements, API agreements, whatever. The resulting case was one of those as well. So, well, you violate our terms of service. It's a breach of a contract. I think that the Van Buren case sort of killed that as a theory of liability under the Computer Fraud and Abuse Act.
Right. And I'm not talking about using CFAA to enforce, you know, API use or anything, because I don't think you need to, because you have the contract, you have, it's a much more clear privity and
Yeah, but can the data subject enforce the API rights of the other company?
no,
That's the problem.
That's the problem, but that's why we need comprehensive federal privacy legislation.
You're not getting an argument here.
Yeah, but if we're looking for ways for the website operator to be able to, you know, make information available to people in a controlled way, then that's why I bring up the API. Lorraine brings up good points, though. You know, but about preferential access or limited access, and that could use more regulation. And but there's also, you know, if you're dealing with a company, there's anti-competitive law that could possibly help.
And
you
of course,
out.
the company that got it through the API then has to enforce the same terms and conditions and not give fourth party access to it as well.
Exactly.
So what I predict will happen is the EU will get all over this, and they will say, you can't do this. And then US states will start following that model. And then, you know, I mean, I'm not looking at federal law in this for this issue at all. It's got right now, it's the European leading privacy on the global stage. The states are following the EU. The US is trying to maintain the status quo. It just negotiated another privacy shield. And the federal government is paralyzed.
And the problem is, of course, from a privacy standpoint, when you start applying these rules to things like social media, okay, I want my social media out there. I want it to be as public as possible, especially LinkedIn, because I want to find jobs. I want to make connections. So
Mhm.
I want it to be really public. What I don't want to have happen is that if LinkedIn now owns the data and they own it forever, they use that as a bludgeon against every other competitor. So,
Right.
and you don't want to use privacy law to give LinkedIn a monopoly.
All right.
Agree.
All right,
The right,
we've
the
got-
right should be with the people who are,
Right, the data subjects.
yeah, exactly.
Okay, we've got 2 more questions here I want to get to. Brian Malone has a question that I think is appropriate for Lorraine to chime in first. Quote, how do we hold big tech companies compliant to best practices identified in the ACM Code of Ethics? Likewise, how will the ACM Code of Ethics be implemented in varying state and federal laws?
So it's a really good question. And generally, codes of ethics don't have legal teeth. They don't have enforceability in there. What they might have, depending upon what professional organization we're talking about, such as the ABA or the AMA, in terms of medical licenses and law licenses and so forth, is that they may have the enforceability to remove the license, to rescind that. In ACM's case, that is not a possibility because there is not a license that is given by that professional society. So there are varying levels of enforceability depending upon the society that's indicating these professional conduct codes. And generally, professional conduct codes are intended to serve as a guideline. So they may serve as a framework by which law is built, but directly itself will not have the enforceability on there. So I know it's not the answer you're looking for, but we recognize it as this is something that will guide good practice, good conduct, but we also need laws in place to be able to provide regulation, oversight, enforceability, and so forth.
Anybody else want to chime in on that one? All right. Our next question from David Bowman. Is any government agency or body working to revise copyright law to give individuals personal property rights over data about themselves? Would corporations lobby against this? I think we can answer the second question pretty quickly, and the answer is yes.
Right.
Anybody disagree with me?
On the second part, no.
Okay, who's going to answer the first part?
Well, there is a movement for data ownership where companies should pay you to use your data. And you should actually be able to make money on it. Data, your sovereign data rights, that you should own your data and they should have to pay you to use it. And that is a movement that's getting some momentum. And it's attractive to individuals because there are several people that have analyzed it to where you could get a nice little check every year or every month just from people using your data. And if that's okay with you, then they're saying then at least I get something out of this. And you know who's using it because you're getting, some money from them. And so that part of it, I actually at one point helped draft a statement about data ownership, but that's what I know of, but not anything legislative.
I think Megan might have something to say about this. I mean, no, not necessarily. I think one of the problems with this movement towards obviously where we are in terms of commodification of data is that on the first reaction, it seems attractive to think, well, finally, people will be compensating me for what they're doing with my data. But there are problems in terms of the ways of which this affects marginalized populations, disenfranchised users, and from my understanding of this, and again, not the lawyer in the room, it's not the route to take. I remember raising this question, Megan, when I was at Epic in the fall of 2018. So why not do this kind of thing? I just got a flat out no, and I'm never quite sure what the legal argument was. But it was clear that that wasn't, from those perspectives and those opinions, that there were so many problems attached with that path to.
One other practical concern is we go from free essential services to paid essential services with a discount if you're willing to let them use it. So Google becomes a $50 a month subscription, but if you let us use your data, it's free.
Right.
And now you get to say, well, you signed up for it. And so, you know, the reason why your flat screen television set is only $300 is frankly because your flat screen television set is spying on you. What's different is visibility and notice. Okay, people don't know that. But if you had a choice between a $300 flat screen TV that's collecting information about what you're watching and a $1,000 television set, I dare say most people would say, I'll take the $300 TV. And in fact, AT&T tried that with their service, where they had a privacy enhanced service and a non-privacy enhanced service, and nobody opted for the privacy enhanced service.
Yeah,
You would
marginalized,
Go ahead, Megan.
marginalized communities are already subject to more surveillance than others. And so the pay for privacy model, which is essentially what this is, you would be paying for privacy, would just make the gap much worse, and would be just a very attractive way to continue and enhance surveillance of these
Right.
marginalized communities who will take the cheaper.
Yeah,
And-
paid for use becomes pay for privacy.
Exactly.
Megan, in your arguments before the Ninth Circuit, you advanced the theory of privacy in data that was already publicly disclosed. You advanced it in terms of collection and use. Where did you get the legal basis for making that argument?
Well, there has been a distinction between access, collection, and use of data and the rights attached to those things. Ever since information privacy has been a thing, right? Back to what is it, Adam Weston and the Hugh report. I think that has very strong roots in privacy law. It's not a new thing.
Hey, can I ask Megan a real quick question? So this was in the Ninth Circuit, Megan. Are there other things similar in other circuits, or do you think that this was partly decided this way because it's just the Ninth Circuit and it could be different elsewhere?
I don't know of any similar cases involving scraping of personal information. I don't know if anybody else does. They're still out there.
The ones I can think of involve anti-competitive scraping of personal information. Okay, not so much like I'm leaving and I'm taking a list of all of your customers with me and stuff like that. That's where they tend to sue. But you know, getting back to the whole trespass thing, fundamentally there is a question of whether or not I, as the owner of a website that collects data, whatever it is, private, commercial, privacy, whatever, can use the trespass law to dictate to people what they can do on my site. You know, if you look at the New York City, you go into a park in New York, it has a sign that says, property of the Parks Department, no smoking, no littering, no gum chewing, no skateboarding, whatever the list of things is. And there's this concept that a use of the site that is inconsistent with the desires of the owner of the site becomes a trespass. And that's common trespass law. And one of the problems is after Van Buren and under the rationale of high Q, we may not be able to control what people do on our sites, putting aside the privacy issues under terms of use, terms of service, and then that renders these things essentially only enforceable through civil breach of contract damages.
All right, we have one more question. I'm going to ask it, and then we're going to wrap up. So keep the answer succinct, to the point, but no more wording than necessary. I cannot pronounce your name, sir. I apologize. Your first name is Oshani. You know what your last name is. Quote, regarding data ownership on the web, What are your thoughts about the SOLID project that is spearheaded by the inventor of the World Wide Web, Tim Berners-Lee? Who wants to take that one, if anyone? Lorraine?
I have no idea.
Let me expand on that and say, I have no idea.
No idea.
Well, Amazon considers the data they have when you sell a product. So for example, a woman I know who developed Hint, it's great. She, Amazon was selling the water and she said, well, I want the list of who's buying it. They said, no, we're not giving you the list of who's buying it. So she went off and started selling it herself. But you know, that was their proprietary data. So I mean, I think today they would say, what Radio Shack wouldn't sell you something unless you gave them a mailing address. I don't know. I never had that issue with Radio Shack, but they can certainly say you have to give us your address if we're sending you something, or we have to, you know, send you a paper or send you a filing at the end of the year or something.
I never give my telephone number or email at a checkout counter. I have yet to have a store refuse to take my money when I do that. I have stores that refuse to take my cash. They want credit card, but not my payments for their products. Okay, we are done. Adam, am I right? He's not listening to me.
Yes, indeed. That is correct. Thanks for joining us, everybody.
Thank you very much.
Thank
And
you,
to all-
Andrew. Great
and
job
to all-
moderating.
You know, and our panelists, by the way, did this on relatively short notice. And I was extremely occupied in the last week and did not have the input with each of them that I normally do. But I want to take my hat off to all of them and thank you to the audience.
Sure.
Thank you, guys. It was fun.
Bye.
Thank you, Andy.